This is like this.
Live streaming.
Yes.
Okay.
All right, you're good to go, Andrea.
All right, so welcome everybody to the subcommittee meeting. This is the subcommittee of the Ethics Committee on the sale of practice and proper handling of aged client files. Before we get started, I'm going to go ahead and read the statement to remind everybody that it is our duty of the subcommittee to avoid conflicts of interest and appearances of conflicts of interest in performing the duties as a member of the subcommittee of the Ethics Committee of the North Carolina State Bar. Any member of this subcommittee who is aware of any personal conflicts or appearances thereof with respect to the matters before this subcommittee should disclose those at this meeting. Does anybody feel like they have a conflict of interest that they would like to alert us to? No? Good. So this is my first time chairing a subcommittee, so you have to bear with me as far as the flow. I had a chance to talk to Brian a little bit beforehand, but it's also my first time attending a subcommittee meeting, so you have to give me a little slack on that part too. But it's my understanding at this point that everybody has the materials. If you don't, let us know, and Brian can go ahead and send it to you now. But the materials are essentially what was already included in the Ethics Committee packet when we met at the last meeting. And as you know, the Ethics Committee recommended that that this issue go to this subcommittee. And it's my understanding that it's our role today to just, first of all, determine whether we think these, and let me back up for a minute. So there are 8 inquiries and therefore 8 opinions. So we have to look at each one individually and decide for each one individually whether we want to recommend that it go forward and be published for consideration. Is that correct, Brian? Do I have that right?
Yeah, well, I think we'll go through each one of these inquiries and make sure that we have a consensus, but ultimately we're shooting for an opinion that this subcommittee feels comfortable publishing or recommending for publication to the full ethics meeting, or a full ethics committee, excuse me, in October.
And that goes to whether we feel like it's of sufficient interest. And so basically, I mean, at this point, let's just go ahead and jump in because of the fact that we have 8 opinions that we have to look at, and we only have an hour worth of time. I will tell you that, it would be great if we can get all this done in an hour. If we can't, when we get close to that hour, Brian, if I don't pick up on the fact that we're getting close to 4, if you could just give me like a heads up, and then we can kind of negotiate whether we want to spend a little more time with this or whether we want to bump it to another date and time. Okay.
That sounds great.
So I want to respect everybody's time. All right. Hopefully you've had a chance to read all through these, and I'm just going to jump in, like I said, and start with the first inquiry. And that goes to the lawyers selling their entire practice.
Right. And Andrew, do you want me to give some background just on this opinion so we're all on the same page? And
yeah, that would be great. Mm-hmm.
Sure. So this opinion was generated from a variety of calls that the bar has received. That we on staff will answer these different ethics calls, and we've had a couple of different situations presented to us over really for a while now, but particularly over the past, say, 3 to 6 months, that have dealt with lawyers selling their law practice and realizing that they've got old client files. They're not sure exactly what to do with them, and maybe some confusion about what is contained in the files and how that kind of dictates what you're supposed to do with those files. And so we thought, as the staff members, thought that this was a good opportunity to issue an opinion that set out exactly kind of the process, try to outline the process for selling a practice because it seems like we're looking at a lot of law practice sales coming up. We know that there's going to be a lot of retirements coming up, and this issue is only really growing in significance. But we're also finding that a lot of these practices, folks have been keeping their files for 30 years, 40 years. And sometimes, that one will that they drafted 20 years ago that they retained the copy of, what am I supposed to do with this? That sort of thing. So we thought this was a good opportunity to answer those questions. And Andrea, I think, to your point about, going through the different inquiries, I think I can, if you would like me to, I can kind of set up the inquiries, just kind of tell you what inquiry number one addresses, and then see if there's anything that sticks out to anyone. We're going to, I think we can kind of presume that everybody's been able to read the opinion, and we can just go from one opinion to the next and see if anybody wants to pull something. So I think there's definitely some feedback that we received at the full ethics committee meeting that I think really pertains to some of the later inquiries, but want to give everyone a chance to perhaps offer their suggestions, comments about any of the inquiries as we move towards a final product here. So I can go ahead and jump in if that's all right with you, Andrea.
Yeah, that's fine. Go ahead.
Great. Inquiry number one is really kind of a one that in some ways may feel like why are we even answering this question? Because it's really asking the question of who is the appropriate person to sell a law practice to? And this is kind of really a product of a number of different comments that I have heard from lawyers that have been asking questions of just, I'm just trying to sell my practice in general, just who's looking to buy it? And that's not really the entire question, right? That you have to, the rules, particularly Rule 1.17 talks about selling the practice to somebody who is competent to take on your client files. It would be irresponsible of a criminal defense lawyer to sell the practice and the ongoing representations to a real property lawyer that's never done criminal defense. That it's still our duty as the selling lawyer to make sure that the clients end up in good hands. So that's what opinion number one goes to. And without getting into the details of it, you all see it. I'll kind of pause after each one of these things, just a very general description to see what are we thinking about this one. Do you have any thoughts? Is there anything that strikes you that is either, I guess, incorrect or something else that you would want to add to this opinion?
So I have a question for you, Brian, as a technical question. So if somebody wants to raise their hand, I'm not seeing it on my screen. Let's see.
Here, I'm going to make you a co-host, and I apologize. I should have done that from the get-go. So now you should see anybody who raises their hand, but nobody has their hand raised right now.
Okay. And if I don't catch it, you can. We're a small enough group where you can just raise it. But let me, before I ask for input, I guess I wanted to just confirm when you said earlier. So the rules here are basically outlining a process for selling the practice, and we can believe, because I'm not aware of it, but just to confirm that there is no section of the rules right now that really gets into this kind of detail that would help somebody and sell their practice, right?
Yeah, I mean, we've got Rule 1.17 governs the sale of a practice, but I think we have limited opinions on selling a practice, and to kind of go through it, even the opinions that we have really only address specific kind of questions that have arisen under that context. And so that's where in drafting this opinion, this is really formed from a variety of questions. It's not just one that came to us, but just recognizing that there have been a number of conversations that I know I personally had, as well as Suzanne and Nicole, with folks that made us think this would be a good opportunity to kind of start broad and provide this type of overview of how 1.17 works.
Okay. Does anybody have any questions of Brian at this time? No. Does everybody feel like this first inquiry is good? I mean, did you have any questions about it or feel that it needed a little more clarification?
I thought it was fine.
Yeah. Okay.
Inquiry
it was pretty clear.
Pretty clear to me.
All right.
Great.
So, so is it, I guess, Brian, for purposes, if we just take these one at a time, then basically we're saying that we don't have any recommendations for this first inquiry. And
Yeah.
assuming that we say, yes, we think this should all go to publication, then it would be, you're good to go with that, right? You don't
Yeah,
need
yeah,
any-
yeah. We can just kind of go from one inquiry to the next and only address the ones that that folks feel need to be changed, improved, anything like that. But if we're good with one inquiry, we can just go on to the next one.
All right, great. Going to inquiry number 2, you want to give
Yeah,
us
so
the heads up on
sure.
that?
So inquiry number 2 deals with a question, another question that we've had in this context. So what can I do when I sell my law practice? I want to just offer some limited services. I just want to do the occasional closing for my friend or my family member, or anything like that. Or even just, I've had longtime clients that that if they need just something little, then I just want to help them out. Very well-intentioned thoughts here. But the rules kind of outline exactly what a lawyer can do once they've sold their practice. The idea, of course, being that when you sell your practice, you can't just sell your practice and essentially open up shop right next door and undercut the purpose for that sale. The purchaser is now a competitor. So it's supposed to be kind of a clean break for the selling attorney to either maybe they're moving out of the county or maybe they are just retiring from the practice entirely. But it's supposed to facilitate that type of continuity of those legal services. So inquiry number 2 basically asks, can a lawyer offer, they're the lawyer in our hypothetical scenario, can they offer limited services, like drafting a simple will or just doing a real estate closing for family members, friends in the area, things of that nature? And the answer is no, because Rule 1.17 does say that, or requires that a lawyer who's selling a practice requires that they cease engaging in the private practice of law within like a 100-mile radius. There's a geographic limitation that's put on there, but there is an exception, and that essentially that the seller can continue to practice law with the purchaser, which is one of those things that oftentimes we see those relationships develop. Lawyer has sold the practice to the purchasing attorney, but the seller has stayed on as kind of an of counsel relationship. That way they wash their hands of the admin and all that, and they're really kind of helping the transition of this firm into the new hands. Also, that a lawyer can provide legal representation at no charge to indigent folks or to members of the seller's family. So there's the rule kind of outlines those different exceptions. And I realize that the sentence there, as I'm reading it, it says Rule 1.17a allows one exception to this rule. And I think it really is, as I read it, I think it really is 2. And the direct quote from 1.17a you see there, but the way that I read it, it's not so much that you have to be continuing to practice law with the purchasing attorney to provide a will to your mom or to your daughter or something like that. I think it's almost like the and that's in Rule 1.17 or 1.17a is really I think it's kind of supposed to be an or, even though it's an and. So I think maybe that might be something that I could change just to say, allows whether it's an exception to the rule or just, or exempts from the rule the following. That way it's just kind of clear that you've got those 2 different things that you can do. But otherwise, that's the answer to the question. No, you can't just, offer limited services generally. Unless they fit into one of those categories that's outlined in the rule.
Okay, thanks. So I want to pull this, and I think what we're going to do, because I want to discuss this personally. I don't know. Does anybody else feel like they want to discuss it, or is it just me? Just curious.
I had a question about it.
Okay, so I think what I'd like to do is just let's go ahead and pull it, and then I would like to see which ones we don't have issues with, so at least we can narrow our focus. So we'll come back to number 2. Brian, go to number 3.
Okay. So number 3, basically, gets to the issue of written notice. And this is one issue that we've had a fair amount of discussion or calls on, just what type of written notice is required of the selling attorney and the purchasing attorney when they are actually completing the sale. And the first question that I think this is probably the most common question, or maybe I should say the most common misunderstanding that we hear about this rule. Can a lawyer who's selling the practice, do they need to only provide written notice of the sale to current clients? The answer is no, that effectively a lawyer who is selling the practice needs to provide written notice of the sale to all clients whose information is being transferred to the purchasing attorney. That's you see there under comment 6 to rule 1.17. And I think that's where this opinion offers that opportunity to clarify just what is required, because so many people think I just have to send it to my active clients and that's fine. But when you're providing information, even for a former client, you're providing their information to this new attorney, that written notice is still required to any client whose information gets sent over to some other location. The idea, of course, being that the client should know where their information is going. If it's their client file, and maybe perhaps I should say it's even if it's a copy of the client file, the client has been provided their file and so forth, but essentially the information that the client generated during the representation is being transferred to a new person. That the rule the comment, I should say, clearly sets out that even former clients whose information gets sent over to this purchasing attorney, they are deserving of some sort of notice of the sale.
All right. I'm guessing that there's going to be some discussion on this, but I could be wrong. How many people feel that we should discuss this? Warren? All right. All right, so we're going to pull number 3.
Okay. And then number 4 basically is kind of a continuation of number 3. The question being that, in light of opinion number 3, does the lawyer have to provide notice of the sale to the former clients whose files are not transferred? If you're not giving those files over to the purchasing attorney, do you still have to provide written notice of the sale? And the answer is no. You really only have to provide notice if you're transferring their files over to a purchasing attorney. And so it just kind of, tries to answer that question that I would anticipate would come up when reading the opinion, as it has come up in conversations with lawyers.
Okay. Is everybody good with that one?
I just have a question, Brian. What is the situation where that happens, where you retire, sell your practice, but you don't transfer the files? What's so
right? It's really, like if you're selling a portion of your practice, you're selling the real estate portion of your practice, or maybe it's just that the purchasing attorney says, I just want your active files. I don't want your former client files. You've got 30 years of files. I don't want those. I want the ones from the past 10 years or 5 years, whatever it may be. And I think that would be where the lawyer, that selling lawyer, is then in the position of, okay, well, I'm still selling my practice. I'm shutting it all down. Do I need to send notice to these folks that I just sold my practice? The answer would be no. Lawyer is eligible to destroy all those files, presuming there's no original documents in there. And they really could have been destroyed probably years, if not decades ago. But that's just kind of the thought in light of the different types of sales that occur, that could come up.
Okay.
Okay. So are we good to instruct Brian that this particular part of the rule is fine, just to confirm?
Yes.
All right. So 4 is okay. Going to 5.
Right. And so 5 is kind of that question that I kind of alluded to in that answer, that, instead of transferring the files, if lawyer just decides, hey, these files are not being transferred, can I just destroy them without notice to those former clients? And the answer is yes, provided that those files fit into the category of files that are eligible for destruction. That category really consists of files that are more than 6 years old, and that don't have any sort of original client property of legal significance that need to be returned. And that's where we start getting into this issue of the original property, original client property that may need to actually be returned, and finding that client and things of that nature, which we get into more in opinion number 6. But this just kind of tries to clarify what has been said. You can see there's 2 ethics opinions cited in this particular answer. And this is, but they are old opinions. And that's something that, sometimes we get folks that have read those opinions and they say, are these still good? Is this still the rule? And so I thought this was a good opportunity to confirm, yes, the 6-year rule is still the rule for files. And at which point the file can be destroyed after 6 years unless you have that original client property.
So I had a question about this. Why did you use it if there's already a rule or rules that address this elsewhere? Even though they're old, why wouldn't we just update those? And I mean, it seems like this could cause confusion, if not confusion, but just why would you want to have this be basically the same kind of thing that's somewhere else in the rules of conduct?
Yeah, and I think I think it's because when you have these old opinions, the old opinions, they kind of stand unto themselves. We don't really go back and edit the old opinions because they were opinions that were issued back in the early 90s. I think RPC 209 is from the early 90s or late 80s. And so we can always reference them. And this opinion, frankly, could be shorter. It could just be, yes, provided the files are more than 6 years old, see these opinions, because this is the more current resource for lawyers to read, where they will be referred back to a different opinion. Just, I guess, kind of similar to any case that references an old opinion or something like that. That just gives that resource. So and I think that's been our experience, where some folks will go and they'll look at the old opinions. They may be very satisfied. That's the old opinion. But I think as we grow our body of ethics opinions, I don't know if it's always been like this, but I feel like I've been hearing more of these questions of, are these old opinions still something I'm allowed to rely upon? Because they were promulgated under a different version of the rules. Like the rules were renumbered or numbered differently back in RPC 209. And so sometimes there's that confusion of how applicable is this? Am I allowed to rely on it in a good faith demonstration of my my professional responsibility? So this is really as much an opportunity as anything, just to confirm this question will come up when you're selling your practice, you're deciding what to do with your files. And the answer that previously was still is.
Does anybody care that it's in there? I'm just asking. I could go either way. I just had that question, but if nobody feels like it's worthwhile to shorten it, then we'll move on.
I don't have a problem with the reference, but I do have some questions about RPC 234 that I think we'll get to later. So that reference is the only thing I'd like to just flag to say,
Okay.
I think we might need some further discussion about it.
Okay.
Okay. Okay, great. Anything else on this particular inquiry? No. So Brian, you got that? Well, I'm taking notes too, but just in case I overlooked it when we come back.
Right.
All right. So now we're on number 6.
Number 6 is this question of what exactly are we supposed to do with original documents? Lawyer is basically in the process of selling the practice, looks in the client files, of which there are many, and finds that a number of the client files contain original documents of legal significance for these clients, such as executed wills, original stock certificates, things of that nature. But of course, these files are very old, and so lawyer anticipates it's going to be really difficult to find these clients and return the client property. So now lawyer's question, this is a question that definitely came up recently. Does lawyer have a responsibility if they are really going to transfer these aged files to another person? Do they have to contact all these former clients and try to return the client property? And that's where the opinion does say yes, that when you are talking about original documents of legal significance, this is all property that belongs to the client. And the opinion goes on to say, you know, that generally speaking, lawyers should return client property upon the conclusion of the representation. I think that's something that I'll just say I've talked to a number of lawyers in this ethics context, the advice context, as well as others that, you know, recognize that there was kind of a, I don't know if I'll say a norm, but that a lot of lawyers would kind of act as that safe deposit box for their clients and keep those wills. But that has produced, and I know we've seen it not just in the ethics context, but in the trustee process that we have at the bar, where, you know, lawyer becomes unavailable, lawyer passes away, whatever it may be, and you've got a lot of original wills sitting in an office, and you know, there's this feeling of, well, it's a 30-year-old will, surely somebody else has executed something else. You know, they've got another will, maybe it's a 40-year-old will, and can't I just destroy it? And there's nothing under the rules that we can point to say go ahead and destroy it, because at the same time we've also received those calls from folks saying, I'm trying to find my mom's will. My mom passed. I know she had it drafted many years ago by this lawyer, and I can't find this lawyer. You know, it turns out the lawyer passed away 10 years ago, and they don't know where the will is. So it's trying to, I think the opinion.
As he passed away.
Yeah, right. I think Root Edmondson, whenever we get those calls, he would always tell me that the answer to the person looking for mama's will is to check the shoebox in the closet. That was the official answer from the state bar. But nevertheless, the opinion tries to kind of address this issue of what are you supposed to do with original documents, and really try to emphasize that it's our responsibility under the rules to do one of two things: either return it to the client, or if you're going to hold on to it, you essentially need to safeguard it. You need to safekeep it, because it is client property. It has legal significance. And it's not just any client property, it's client property of legal significance. And if you've been entrusted to keep it safe, then it's our duty to keep it safe and provide notice, particularly when it gets transferred. So you don't have a situation where, oh, the will was transferred to a purchasing attorney, now they're looking for it, but they have no idea that the firm was sold 10 years ago. So that's opinion, or inquiry and opinion, number 6.
So I have a question for you, Brian. So this talks about what to do with original documents if you can't find the client under the auspice of a sale.
Right.
But where would you go where would we go to look if it was, let's say it's not a sale and we just have a bunch of wills in our drawer and
Right.
we want to clean it out?
Just want to retire. Yeah. And I think the answer in this opinion would be the same. That's what I would advise folks if they call. It would be the same whether it's a sale or whether it's just you're just retiring and you're deciding to close down shop, which we could make a point in this opinion to say, you know, this rule applies for any lawyer that's winding down their practice, whether it's being sold or simply closed down.
Well, I think I would like some additional reference like that, but not only winding down the practice, but anytime a lawyer wants to get rid of documents.
Right.
Yeah, I think Andrea's right. I mean, if you read this opinion today and you went like, you know, gee, I should have had a V8. I've got 50 wills in my pocket before we get too much further down the line and my clients scatter, I should go ahead and address this. It's sort of similar to me, like the one earlier, the inquiry earlier, where it's like, it's not the retirement that triggers what you have to do here. It's the fact that you got client papers in your files. You know, you can't dispose of the file, whether you're retiring or getting to be 6 years old. It's just, you know, it is the fact that it's the paper that's in there that is an important client document that triggers the responsibility. There is no other triggering event. I mean, you know, your triggering event is that there's important client documents in there, or client property in there. If you, you know, Andrew's right, you might just be changing offices and it's like, gee, I'm ready to downsize, or I'm ready to, you know, I now been putting all this stuff on you know, electronically storing this, and I don't need to keep these originals. I'm going to send them to the client. You know, you need to, it's really it's the disposal of important client property that's the trigger here, not the sale. or not the retirement or anything else.
And I think when we were discussing this in ethics, there was a distinction. There were those who said, that said, hey, I never keep original documents. I give them to clients. I only have a copy. And then there were other people who said, no, I do this kind of practice all the time, and clients want me to safeguard it and keep it. Certainly the easy answer is don't keep original documents. But if
Right.
you have a practice where clients have really entrusted you and felt secure with you having them, as opposed to keeping them in the house or worried about something may happen to it, then you really have to address that.
Yeah, no, that's right. And I've seen it from both angles, both when I was in office counsel and in the ethics department, that folks have strong preferences. And particularly when you get to, I think, smaller communities, there is kind of seeing the lawyer as, well, this is kind of a foundational spot. I'm just going to leave it with you. But also from that, when I worked on trustees, went in the office of counsel, saw a lot of problems come up from that. So it becomes quite messy. So that's I think the opportunity in this opinion, however this comes out, and I would love to make an opinion that's going to be helpful to lawyers as to what their responsibility is, but also provide some guidance about what you're supposed to do. And there's probably a lot more that can be said. I know you see at the end of the opinion that I wrote this probably generic and perhaps unhelpful statement that, if client property is not actually retrieved, you make the effort to try to get the notice and you find the client's address, you give them notice. But essentially, if the lawyer can't get the client to come get the will, and there's no, I guess maybe the question is there an alternative place or suitable place of safekeeping? Because you can't just say, well, hey, I gave them an opportunity to get their will, I'll wash my hands from it. You certainly couldn't do that with entrusted funds. And so this is kind of akin to that because it's legally significant property. So you have to do something with it. The reason that I did not say specifically, try this, try X, Y, or Z is because depending upon the county that you're in, you might have different options. I know I've been again, in the trustee process, we've had trustees appointed in counties where the clerk was willing to take in all of those wills. We've had counties where the clerk absolutely refuses to do so. And then we ended up getting a court order instructing the clerk to take possession of that. And that's always kind of my go-to recommendation. But again, I don't know that we can give a specific directive because each county handles these things differently. It's just on the lawyer to figure out where is a place that essentially I can put the property such that the client can access it. The client will know where it is, or maybe can reasonably find it. And it will be safe. Because unfortunately, there's really no escheat process. This is where escheating comes in for trust account, right? You can send money to the
Right.
escheat office and register the client associated with it, and they can go claim it. We don't have that for this type of property, so we have to find something else. But that's really going to be kind of a case by case, or maybe even county by county basis.
Okay. I'm going to go ahead and request that we pull this for
Okay.
a little more discussion. Does anybody else have any comments at this point about that, or do you want to just wait?
Oh, wait, I got lots of comments.
All right. So going to number 7, transferring of the original documents.
Yeah, so this one ends up kind of looking at the transferring those documents to lawyer B, and but you didn't provide that notice. Kind of what's the consequence? And this stems directly from a situation that was that I had advised somebody on, and really the answer being that, like, if you didn't provide that notice, you've transferred all those original documents to a new lawyer. You thought you washed your hands of them, so now it's coming back that that essentially somebody's looking for those documents and they don't know where to go. Does the lawyer have to essentially unretire and perhaps kind of fix the situation? And the answer that I gave in that situation that I wrote here was that yes, that essentially that rule 1.17, to be clear, is a really exceptional rule, because it's the only time in the rules where a lawyer can essentially get rid of their professional obligation to the client, to stick with the client, to safeguard their property, to keep their client file, all that kind of stuff. It is a way that you wash your hands of professional responsibility or transfer it to another person. So the only way that you can really achieve or maybe kind of experience that very unique thing under this rule is if you comply with the rule, which is supposed to set out the different procedures and safeguards for those clients. So if you don't provide the notice, then yes, you still have an obligation to provide that notice. You have an obligation to perhaps fix it. That's what the opinion essentially says. Now, it doesn't say it's all on the selling lawyer. The purchasing lawyer has taken receipt of those files. And so the purchasing lawyer has some obligation too, to ensure that basically the information, the documents that you are holding, the person who benefits from them knows where they are. Otherwise, it's really kind of, it's just, I think, perhaps just unfair to the client that they don't know where their will is. And we're saying, lawyers, you don't have an obligation to go back and inform them that your will is actually held by another person. I sold it a couple years ago.
Okay, Warren.
Is this opinion just talking about the whole file or just the original documents of legal significance?
The original documents of legal significance.
That's it.
That's the kind of the crux of the opinion that's or described there in the inquiry.
So if there are no legal documents of significant, no documents of legal significance, then and we're only talking about former client files.
Right.
They have confidential information in them, but aren't. Otherwise, you could destroy them at 6 years or whatever. What is that lawyer's duty if
it's a great question,
if they didn't send the proper notice? And that's where I've got a lot of questions throughout.
Right. And so that's where it's like I have a kind of a technical and a practical answer. The technical answer is, remember, we said if you're transferring files from the seller to the purchaser, that triggers a notice requirement. And that's regardless of original documents or anything. It's just supposed to go over there. As far as going back and fixing it, and this could be something where, maybe we need to offer some sort of clarification, maybe in the rule or the comment itself. But when you're talking about, clearly there's files with original or documents and all that, that's what this opinion addresses. But if it doesn't have original documents, that file is technically eligible for destruction. At least I'm kind of presuming that it's an old file, it's an aged file. And I think it's more practical to recognize that a written notice may not be required in that scenario when there's nothing that the client really we need to return to the client. It's eligible for destruction. It could be thrown in the shredder. It could have been thrown in the shredder back when it was sold, and it could be thrown in the shredder now. I have a hard time saying that, you have to go back and notify everybody, because frankly, all those files could be transferred back to the original selling attorney. In theory, like if you came across this issue, purchaser could say, you know what, take all these things back. And then the selling attorney could throw them in the shredder right then, because they're all eligible for destruction. And that's where I don't feel comfortable putting the written notice requirement on those types of files. Although I recognize there is a technical requirement to send that notice in the first place when you transfer it.
Because it's still, quote, confidential information. Just because it's in the client file and you got it while you're representing the client. That's a real difficult concept for me throughout all of this, is that in the big picture, where, for instance, when you put this purchase in the context of a real estate lawyer purchasing a real estate practice, and all of the title opinions that real estate practice has in their, what do you call it, that they've done on all the properties they've closed. And this is true of firms all over the state, that they keep those title opinions and they build off of them so they don't have to reinvent the wheel every time they do a closing. And that is extremely valuable stuff. And to a real estate lawyer who's selling their practice and who has been doing real estate closings and collecting those opinions for 40 years of practice, the practical impossibility of contacting or even figuring out how many of those former clients are even alive to be able to give notice so that they can sell this valuable practice to a purchasing attorney when those title opinions were created for the client, but in order to give to other people, right?
Right.
I mean,
It effectively becomes work product in a way, because it's something else that you can build.
that title opinion. So I think we need to address a lot of different things here because it is, the way I read this, we've just gutted the purchasing value, the fair market value of real estate practices that lawyers might want to sell to other folks by saying you can't do it unless you get in touch with every single client about their former and get their permission, because you don't want to destroy the ones that are 6 years or older. The whole point of selling it is that the purchase wants to buy people want to buy their file, right?
Right. And I think there may be a solution. I don't know if everybody kind of has a similar concern. I know I will tell you, I have a similar concern because this, again, the rules are supposed to be rules of reason. They're not supposed to create these hurdles and kind of just annoying roadblocks. They're supposed to protect clients and enable lawyers to operate their business really in service of those clients. And really the thing that I see that I'm going to go ahead and share my screen here. It's this is the comment where the written notice thing gets in. I know we're getting into the weeds here just a little bit, but I feel like this might be something that's worth just suggesting. And if we agree with it, it might be kind of in our minds as we look at the reasons that we have questions about other inquiries. But this is the sentence right here that I've highlighted that requires that written notice regarding the transfer of files to all former clients whose files will be transferred to the purchaser. I wonder if that sentence could essentially have an amendment that says, instead of after purchaser, there's a comma and it says, unless the file is eligible for destruction. Because then you don't have this written notice that's required if the file is 6 years old or if the client has consented to destruction. And that is something that can be addressed, whether you're talking about, I mean, my goodness, you could address it with the client at the end of closing, saying, I'm giving you your client file and I'm not keeping a copy. Or maybe it's in the fee agreement that, that you are signing off that I can actually destroy this thing at such and such date. And I've given you your copy of your file, whatever it may be. Because I know, especially with real estate closings, I mean, as someone who went through a closing about 3 years ago, I got a copy of a lot of different things, So I'm just wondering if that might be a helpful thought as we move through this. That might be a place for an amendment, because that sentence in that comment may be the thing that is creating a lot of heartburn.
I see Missy has her hand up.
Yeah, Missy, you wanted to say something?
Question, and forgive me because I'm not really familiar with how a real estate practice operates, but Warren, from what you were saying, when I read this opinion, I was reading it as a warning to all of us to be cleaning out our files that are closed files after 6 years, because God forbid you're going to try and sell this 20 years from now and you're going to be like, who was that person? Warren, how does a law firm, or can anybody who can explain to me how a real estate firm operates in a way that it would somehow be financially beneficial to hold on to a file that's technically closed?
I can answer that.
Andre can answer that.
I was going to say Andrea or Christina, I bet could answer that.
Christina, you want to go first? No, okay. So just to give you a little background, we're in a small town. My firm has been practicing real estate law for probably over 40 years. We have a whole storage room. We call it an alley, but it's basically maybe, let's say 1,500 square feet of nothing but real estate files. It's a lot. It's huge. It's and we've kept them through the years. And to answer your question about what the financial benefit is, if we have to do a closing, we have to do a title search, we can start off from where we left off the last time we did that title search. So instead of going back to the beginning, or 30 years or 35, whatever the amount of years we have to go back, if we did a closing 5 years ago on the same property, we would only have to do a search from 5 years back, because we have all the benefit of the previous search. So that saves a tremendous amount of time. And I can say though, that's more old school, where we were, our firm's been saving these hard copies. Now, in the last, maybe 5 years or so, we've been trying to make it more paperless. Mm-hmm. And we start disposing of documents early on, and then just saving what we feel like in our computer. We'll save what we feel would be necessary to accomplish that that goal of just not having to do a complete search and only being, only having to go back a few years. So I think that my opinion, listening to all this, there's this two things going on. One is old school, like in the old days, also because we're a small practice and we do estate planning too, we would all the time hold on to wills. In the last 5 to 10 years, we've realized there's not a benefit to that. It's more heartburn than anything, as we've been discussing. And so I can see that the new generation of attorneys are probably going to be less likely to hold on to original documents. And I don't know if everybody agrees with me, but that's just my experience. Did that answer your question?
Yeah, yes. I guess I was wondering, is there, and maybe it was just the way I heard it, that there, in the sale of a practice, is the practice then valued in a way to say, is that part of the valuation of the practice, in terms of saying, we have these, 500,000 closings that have been done, that these people are going to come back, and is that, Warren, you seem to be nodding.
Yeah, I would think so. I mean, it's one thing to buy a practice, a real estate practice, because of the value of that past work done, right? For those pieces of property is really what we're talking about. The property that gets sold, again, there might have been interim sales by other attorneys, but if you've sold that property before, you can go find it and go from that date, right, Andrea? Go from that
right, because the work, you have to trust that the work you did was good at the time. Good. So if we did a closing 5 years ago, we would only have to go back 5 years to see,
and that meets standard of care. Whereas if I buy your practice, Missy, knowing your own client, your client's criminal background is not valuable to me necessarily, and I don't need your files, so to speak. So the buying your practice is more maybe buying the networking of, I don't know, but your files themselves are not probably going to be very, and which to me raises an issue too, that let's say Missy was sloppy and didn't get rid of old files and had files without legal significance, with documents without legal significance in them that were older than 6 years old, but had incriminating stuff about clients that she represented in the past, that they don't want that to go anywhere. Seems like those files should be treated different than title opinions in a real estate file that are still in the, you see what I mean? We're not, we got to be careful we don't cut off real estate lawyers and the value that we got to figure out how to allow that to happen, but then don't allow Missy to give away, her serial killer client's confessions to her in her office of killing 20 people to the next attorney who buys her practice.
Warren, my clients are really just misunderstood. Just
I understand.
So,
Alleged confessions to you.
okay, so I'm looking at the time, and it's 3:54, and this hour or 55 minutes more or less has demonstrated that I think these 8 inquiries, Brian, even though we knocked out a couple, they're very interrelated.
Yeah.
And this is not, if you guys agree, this is not something that's going to be resolved even in another meeting, I don't think, realistically. I think I see this more, I don't want to say long term, but I see, this is going to take more than one more hour.
Right.
Does everybody
I agree. I think
I
the
agree.
one thing that if you all wouldn't mind some feedback right now, because what I've heard, the notice requirement, I think that's something that is,
We need to talk about that.
yeah, it's kind of the domino, like that leads to a lot of other things.
Yeah.
With what I guess just in terms of the general feel I'm hearing is requiring notice to all clients whose files have been transferred, just any former client. That seems too broad or
That's
unworkable.
yeah. I mean, we could take it, Brian, excuse me, but if we took just a head count right now, I'm going to guess that everybody, it could be wrong, but that everybody's comfortable with the suggested amendment that you had, and that is, if a client, if a file is already eligible to be purged, then notice is not required. And I'm okay with that.
I'm not sure I'm okay with that in the broad sense because of the situation I just described with Missy. Missy didn't destroy old files, but those old files have very incriminating information about some of her clients. She could have destroyed them, but she didn't. And then she hands them over to a purchasing attorney without giving notice.
But was that, does that proposed amendment that you had up on the screen, Brian, does that open the door for that situation, or I thought it was a little more narrow?
Yeah, I think it was really just kind of, the proposed amendment would effectively constrict the written notice requirement. That you only have to provide written notice of a proposed sale if you have a client file that's transferring to the purchaser that is not eligible for destruction. And I think that's what Warren's saying, that that maybe there are those files that maybe it's a 20-year-old file, and that person's information is going to a purchasing attorney, and that person has some significant stuff that would probably want to know it's going over in this person's hands. And that's where I see exactly what you're saying, Warren, but I also see that as, well, now we're trying to craft a rule for 2 very different practices. And
I agree. And that's why I think it's very complicated.
Yeah. Well,
David?
Just one quick question, and I agree, Andre, we're going to have to come back, and this may be one of those, when we've done it occasionally, is maybe try to find, even if we meet again, try to find an hour through the October meeting for us to actually sit around the table, if that's possible. Just a suggestion. The question I had was this, Brian, and I think I have just been wrong about this. I took this to be that you had client property in the file, or there was client material in there of value. Is that an or, not an and, correct?
I guess that is, see, how would I answer? I guess I'm kind of looking at those similarly, because I'm considering the document of legal significance to be client property that the lawyer is safeguarding. And that's not to include, the draft complaint or even, I think, closing documents. I've told folks when they've called for advice about their real estate practices and saying, do I have to return all these closing documents? And it's really kind of to me, I am generally presuming that, no, I don't think you have to return all those documents, because I believe all the documents of legal significance for the client have been filed with the Register of Deeds, or they've been provided in some way. You might have title opinions. Legal significance is that the client's property, though, it's already been provided to get them title, that sort of thing. So I use the term client property and the documents of legal significance almost kind of in a similar vein.
I think that there's, I guess what I'm saying is that there are two different things. It could be a document of legal significance to Andrea and her firm to leverage up off of the prior title notes.
Yes.
But it's not of legal significance to me as the client. And so, what we're talking about there is lawyers as opposed to the public. And I think or the client rather. And I think that's why there's a difference in the rule, is because the focus was on what you're doing, you the lawyer are doing with respect to client property or documents of significance to the client.
Yes.
And not that adds value to the file, because certainly not having to go back to 1780 or 1620 or whatever it is to do a title search is of enormous value, but it is not of enormous value to me when with respect to that piece of property anymore. And so I think that's why there's a difference there. And I don't know. I mean, we can try to fix that to protect the lawyers who are purchasing and protect their value, but it is not a client. It's not a client issue. It is a benefit of the bargain issue. Looks to me like.
Yeah.
That's why I don't think it's addressed in the rule, because the rule is only focused on the client property. And I guess, just one ancillary question to that, and so maybe a new kettle of fish, which we can stew later. If I have a Xerox copy of your will, but not an original document, that's not a legal document of legal significance. However, it could be a document of client significance. If you can't find the original will, could it not? I mean, I don't know. I just think it would. So that's what I think a lot of lawyers have is, I'm not holding your original will, but I have a copy. I'm keeping you taking the original with you, but I've got a copy of the will here that you signed. A lot of that's for risk management. This is what this is actually what we did in this transaction. I've kept this Xerox copy of it, but it is not it's not for that. So I don't know. Sorry to roll another one out there. I know we got to go.
Okay, so it looks like Judge Bell, you wanted to say something, and just
as it relates to
get off.
Yeah, just as it relates to, I would suggest we try to have a September meeting and see if we can make some more progress before the October meeting. I wouldn't like to see us wait. I'd like to have another subcommittee meeting in September.
That's a good idea, and I am supportive of that. Brian, can you go ahead and try to coordinate it?
Oh, yes. I'll do that. And I think, there's well, we can all continue to think about exactly where this goes. I know one option, just kind of the last thing that we can think about here. If we have come up to ethics opinions before where the inquiry and opinion becomes so complicated, or maybe just that it would be more confusing than helpful to actually issue. And if that's the case, then we do have the option simply to not write about it or address it, because addressing it in one context leads to problems in another context and so forth. So that is an option as well. But I think there's a lot to kind of unpack here. And I think this was, helpful kind of getting a head start to a next meeting, but I will poll for availability in September, and we'll see if we can kind of put our heads together again and continue on.
And maybe try to do an hour and a half instead of an hour.
If that's good with you all, and this, I could talk for all day about ethics if you want to. I don't want to just presume that.
That's for damn sure.
Hey guys, this is Stacy. I'm sorry my Zoom didn't work. I'm out of the office, but I have heard about half of this, and I think I'm in agreement with another meeting.
Great, thank you.
Okay, great. Thank you, everybody. And this will conclude the meeting, and Brian will be in touch. Okay.
Yes. That
Okay,
sounds
all
great.
right.
Thanks,
Thank you.
everyone.
Thanks,
Bye.
y'all.
Thank you.